Hi everyone. Today we're going to talk about private school versus public school, how the court decides in a situation where both parents are not in agreement about that. So first of all, the court does not have the authority to force a parent to pay for private school. And we're talking about private primary school, not daycare. We're talking about school, actual school. And if one parent wants private school and the other parent wants private school and they don't want to pay, but the parent who wants it pays for it, the court is not going to object. So we're talking about a situation where one parent wants private school and is willing to pay for it, and the other parent does not want private school and wants public school. So we have a very good academically driven public school and private school. It seems very obvious to say, well, if the parent wants private school, the student-teacher ratio is very small and therefore private school should win. However, what if the private school is religiously driven? What if one parent is Jewish, the other parent is Catholic, and they're putting the child in Catholic private school? Then we have a little bit trickier situation, because then the court has to look at many reasons how to decide this particular issue. And the reasons all have to do with one and only one thing. What is in the best interest of this particular child? Let's say the child is 6, 7, living most of the time with mom. And in our example, let's say dad wants to change the school. Well, in this case, the court is going to look also, what is the schedule? If dad has only 2 weekends, then most likely the private school will win, because then mom has to drive to a different location. Usually it's longer, half an hour longer, to get the child to that public school. If I were in the place of mom, I would compromise and find a private school next door that has no religious affiliation in order to avoid that religious conflict. And the court would look at the distance from school to the parent, to each parent, at custodial schedule of each parent. So if one parent has less time, then most likely the other parent should be, it's not about the parent driving, but actually the child waking up earlier, half an hour earlier every morning, which is a big deal for a small child. And then also the traffic back from the school might be different. So all these details are going into decision whether or not a parent should change to a different school. And ultimately, of course, the biggest elephant in the room is the school rating. Is the public school has a good rating? The private school has a good rating. Some public school have better rating than the private school. So the court has a very difficult assignment to look at all these factors to establish what is the best for this child. It's not just private public, it's way more. Religious, schedules, driving time. Does the child have special needs that the private school or public school can meet? Those factors are going to be very crucial. So when you draft the declaration, you have to think ahead and involve all these factors, include them into the declaration. Another big mistake people do, they wake up in 4 months before the school starts and, oh my God, we don't have an agreement, I'm going to file an emergency request, order shortening time to decide about school. No. Most cases will be denied if someone is not filing a year before the school starts. Really, a year. I'm not kidding. Because when someone files a request for order and it's going to be heard on a non-emergency basis, school change is not an emergency. There is no irreparable harm to a child to go to a private school or public school during the proceeding, then the court will potentially take the matter under submission sometimes. So the court needs the time to decide. Sometimes it's even potentially necessary to have a longer hearing called evidentiary hearing, a trial on this issue, because it's a big deal where the child is going to go to which school. And so don't make the mistake by filing it on a rushed basis. It's going to be denied. unless you have a compelling reason and can prove there is an irreparable harm to the child, file it at least 9 months before, if not a year. And the way you do it is either hiring a lawyer, a good quality lawyer, or if you cannot afford it, then you have to fill out FL 300, which is the form in order to get court's attention and time. You fill out the form, fill out the declaration, file it, pay for it, and then you will get a hearing date. You got to serve the other side at least if in person, 16 court days, not calendar days, court days before the actual hearing. And the other side will have 9 court days to respond, and then you will have 5 court days before the hearing to reply. And then the court hearing could be via Zoom or in person. So you got to check with the local rules and local website. If you like the video, click like, subscribe, and I'll see you in my next consultation. Bye!